All right. So under Title VII, there's kind of two kind of claims that are usually considered. And just so you know, like if you want to like bring suit under Title VII, the way it works is you first go to the EEOC, this entity, and you file a complaint there. Then they do a little investigating, and if they feel like there's merit, then it moves forward. So that's the process. Um, you could file a tort suit if what's happened to you is obvious enough that it could be straight to the courts. But a lot of times things aren't that clear, right? A lot of times discrimination or harassment, it's shades of gray, right? What's okay and what's not okay. You think about the idea of like sexual harassment, which we'll talk about in a minute. We live in a world right now where it's a pretty difficult thing, right? Where we're pretty sure some of these rotten guys that have been caught up and caught through the hashtag Me Too movement, where women are finally speaking out about things that have happened to them, we know they're pretty rotten and they deserve to get in trouble, right? To lose their jobs or whatever. But there's probably other people who maybe their situation's more innocent. And maybe they said something inappropriate one time, and when someone said, hey, I don't appreciate that, they were like, I'm sorry, I didn't mean to. And sometimes they get swept up in it too. That's the hard thing, right? We're living in a day and age where it's a zero mistake world when it comes to harassment. You know, you have to be careful not to even imply it, not to compliment someone on telling them they look attractive today, because that could seem like it was sexually oriented. And that's a challenging world we're living in right now, right? Rules and laws and things that protect people from being sexually harassed are good things. But always with any rule or law, there's always the potential for someone who maybe with a minor infraction or even an accidental or incidental infraction gets swept up and is punished like the big time evildoer, right? And so this is the challenge we face in today's work environment, to try to be kind and friendly with each other, but not be so friendly that it looks like I'm, making a pass at somebody or something like that. That's a real challenge. So two types. One's called a pattern and practice complaint, and the other is what's called a reprisal and retaliation complaint. So what that means is under disparate treatment, that means an employee says, I'm being treated differently than other employees based on my race, my gender, my religion. Is that it? National origin. So there could be a pattern and practice of that, meaning they do certain things like black people never get promoted at this place, or women never get the desk jobs. They're always doing the hard work, or whatever. And then what you would have to do if you brought that complaint up is you'd have to be able to demonstrate that. Right? There was a recent thing against Walmart, not recent, it's been several years now, but where female employees, associates, they call them at Walmart, female associates said, we're not getting promoted to management. And so they were able to sort of show, look, there's, this percentage of the workforce are women. And then of the managers who didn't come in through the management training program straight out of college, of the managers who were promoted up from the workforce, this much lower percentage are women. So 50% of the employees are women, and only 10% of the managers are women. And that was the beginning of their case. Then they had to show, well, it wasn't, could it be because women employees want to stay part-time because they have families and they just want to work part-time? So those people aren't going to get promoted to management, right? They had to go through this whole process of kind of showing that there was this pattern of discriminating against women when it came to promotions to management. And I believe Walmart finally just settled and said, okay, here's what we'll do. We will review our practices. We will, they made a list of things they would do, and the people bringing the suit, I guess, felt like that was a sufficient solution. The second type is what's called a reprisal and retaliation. This is where maybe I've done something that was completely within my normal rights, but because I'm a woman or because I'm Mormon, or because I'm whatever, I'm black or Hispanic, or that there's this reprisal against me. Okay, and a lot of times this comes up when someone files a complaint on this, saying, look, there's this pattern or practice that goes on here where women are mistreated here, and then they get demoted or fired because they filed the complaint, right? You can't retaliate against somebody for filing a lawful complaint. So that's disparate treatment, the idea that you're being treated less favorably than others based on that protected status. The other is what's called disparate impact. This one's a little more difficult sometimes to prove. So the treatment led to a class of people being impacted less favorably. So here's a good example. If I'm hiring someone to be a teacher here at EAC, and I put in the guidelines, must be able to live 50 pounds over your head, or 100 pounds over your head, whatever. Does that rule impact one gender more than another? Are there fewer females who can lift 100 pounds over their head than males? Probably, okay? And so it has this negative impact on a whole class of people, and the other big and it's not directly necessary for the job. So if we could show it's necessary for the job, well then that's one thing, right? Like to make that rule, yeah, you routinely will be lifting 50 pounds over your head. It's another thing if we don't have any real reason for it, but our actions are limiting an entire class or group of people. So that's a disparate impact, right? So of course the defense is always that this is what's called a BFOQ, a bona fide occupational qualification, which we'll talk about in a minute, for this job. There's a reason why we have this limitation on hiring. And yes, we know it affects women, as an example, more than it affects men. So, but we have a reason. And as long as you can spell out that reason in court, then you're not really discriminating, okay? So this is, kind of the quote that came up from the famous Supreme Court case on the issue. An employer is not free to use any test it pleases. The test must bear a genuine relationship to job performance. So if you create some job to hiring to promotion to, some test to hiring or to promotion, it's got to bear a genuine relationship to job performance, or else you risk discriminating against a class of people on the basis of that test.